Welcome to the Institute of Advanced Legal Studies in London. My name is Carl Stitchen, and I'm the Director of IELTS. It's my pleasure to welcome you today to the Director's Series of Seminars, a series of regular events on the Institute calendar. Thank you for joining us. It's my great pleasure today to welcome remotely to the Institute Professor Devani Prabhat. Devani is Professor of Law at the University of Bristol Law School with legal practice experience in constitutional law. She holds an LLM and a PhD from New York University and is an attorney at law in the state of New York. Devani researches and teaches migration, citizenship, and nationality from a socio-legal and comparative perspective. She serves on the executive committee of the UK Society of Legal Scholars and is a member of the editorial board of Social and Legal Studies. Devani's book, Unleashing the Force of Law, Legal Mobilization, National Security, Basic Freedoms, was the recipient of the Burke's Prize for Outstanding Legal Scholarship from the Society of Legal Scholars. Her book on British citizenship, entitled Britishness, Belonging and Citizenship, is published by Policy Press and is available open access. Devani is also the editor of a collection on British citizenship published by Emerald Press, as well as books on privatization of immigration control. She was the recipient of ESRC funding for a project on British citizenship and the practice of nationality laws. Devani's paper today is entitled Mary Kondo-ing Through Law, How Law Creates Foreignness, a great title. She'll speak for about 40 minutes, and questions can be raised by our audience members in the Q&A function at any time. I will then attempt to moderate the questions in the discussion period, and the seminar is scheduled for about 90 minutes. So with that, by way of introduction, I'm very pleased again to welcome Devani, and over to you.
Thank you very much, Carl, and the IELTS team for inviting me and organizing this session, as well as for to Dali for her technical support today. And all those who have joined us for this discussion, welcome. If there is something that I just touch upon but cannot explain or talk about fully, I hope that we can bring those things back when we have our discussion at the end. I'm really looking forward to that. I will come to the title of my talk and why I bring in Mary Kondo to it in a little bit. But first, I think I want to talk a little bit more about the idea of foreignness and the function of law in creating foreignness. I've drawn on the works of a lot of scholars and their ideas on foreignness for this paper. So I want to develop that a little bit first. So the first scholar whose work I have used is George Simmel, who is very famous as a German sociologist and critical thinker of his times. And he's famous for having written this piece called The Stranger as well. And so Simmel's writings, they are very similar in some ways to Max Weber's style of ideal types. But how he would develop it is in much more literary style. So he would, he explains the stranger as someone who is here today, but not gone tomorrow, like they're there to stay tomorrow, but they reserve the right to leave sometime in the future. So this is essentially a person like a tradesperson, maybe, who comes to do trade, who does not share the history and cultural bonds of the existing people, but who then develops a relationship and who becomes quite important in that society while maintaining a certain social distance. And because they do not have the roots in that society, they can leave sometime in the future, potentially. So this work has actually been used by a lot of people looking at asylum seekers and migrants, or even intergenerational development of belonging, sense of belonging, etc. But for me, the work really captures an essence of how long-term residence and long-term residence as a category in law is understood. Long-term residents are here today and not just going tomorrow, but they will have connections elsewhere and potentially might might leave in search of other destinations as well. So they are somewhat disruptive in the category between who is a citizen and who is an alien, who is foreign. So they retain a certain degree of foreignness, but remain, mostly in Zimmel's work, a positive character in the societal life. Of course, it's, as we know, it's not always seen as wholly positive. But this idea of a disruptive category of who's the stranger is something that I find really interesting in terms of looking at legal categories in migration control as well. So the next scholar, I'm going to sort of take you through the works of different scholars and their idea on foreignness and who is an alien. The next scholar whose work I'm going to talk about is Linda Bosniak, who's written the book Alien and the Citizen. And she's a distinguished professor in Rutgers and has written a lot about the concept of alienage and how important it is as a category. And this is because she points out that there is a difference between the status of citizenship and holding the legal status and actually having substantive rights. So Bosniak writes about those people who do not have the status, but are actually really valued often in the society they are in and enjoy most, if not more, substantive rights than many other citizens. And the example she develops is that of green card holders in the US who are not technically holding the legal status of citizenship, but whose work is valued. If technical skills, maybe they're in the tech sector or wherever they may be, but they're definitely better placed in many ways to enjoy substantive rights than others who are citizens in status but may not have the substantive rights, such as then she develops the idea of minorities, African Americans, Indigenous Americans, and the way they've had to struggle and are continuing to struggle for enjoyment of substantive rights. So then the distinction between status and rights holding is really important, and the concept of alienage helps us see that it functions differently for different people. And it's not just a binary, are you a citizen or are you not? And I think this is really important in the British context, because in the British context too, it's really not just about who is a citizen and who's not. We have many more categories and disruptive categories over time. So bear this in mind while I take you through some other concepts. The other person whose work, again, is about the concept of aliens, but this time actually from the other end, is May Guy's work on alien citizenship. Now, May Guy is talking about a different issue here. These are people who are citizens, but remain aliens in the eyes of the law until they work to get the law changed. So specifically, I'm talking here from Guy's work on East Asian Americans who were born in the US and still often faced prospective exclusions through the Alien Exclusion Acts, or had to go to the Supreme Court in the instance of the Wong case to establish their right to have American citizenship at birth, which was one of the main cases on jus soli law. But these are people then who really for generations remain excluded, although they are technically supposed to be citizens. They carry on holding what she says an alien citizenship, which is never a full citizenship, for very, very long. And again, we will see reflections of this in the British context when we talk about cancellation of citizenship, where we will see how generations down the line, we still have cancellation as an effect, mainly on ethnic minority British nationals, people who have who are mostly Muslim in almost all instances, or have connections with other countries and are ethnic minorities here. So we can see this idea of the alien citizenship working in the British context as well. So now I'm going to have to come to the title, because obviously, why have I talked about the KonMari method and Mary Kondo's ideas? I think it's really interesting for drawing out some of the functions of the law, especially in the context of immigration and nationality in the UK. The law in this area is really about categorizing people, putting them in certain distinct spheres, and saying this is an organizing of who actually enters and gets to live here in the post-colonial. When I say post-colonial, I should say the post-breakdown of empire, British Empire. How do we organize that and put people in different categories? And the law's function in this has been one of organizing and discarding sometimes people, just as Mary Kondo in her method says, discard some categories, then find what's important, what's really important, keep those categories. And then she says, after you've finished discarding, organize your space thoroughly and completely. And then she says something that actually has never happened in the context of immigration and nationality in this country, which is do it all in one go. That is not something that's happened. We see this organizing activity by law happening in a very piecemeal manner through different legislation over time. But the rest of it, about looking for categories and as per usefulness, and you see their own criteria coming in there, is very much a function of the law, I will argue, in nationality and immigration, which is why it's kind of useful to look at this lovely drawer with everything organized, only they don't quite achieve this result. It's still extremely messy because it's people, it's not clothes, it's not objects. That's the real distinction. So it doesn't quite work that way. Anyway, so since I spoke about empire, breakdown of empire, the concept of foreignness, and the idea of aliens and who belongs, I cannot fail to mention this really important book by Anne Dummett, whose picture you have here, one of the founding members of the JCWI, a very well-known anti-racism campaigner who sadly passed away in 2012. And this book is something I have read every page of, and if you can get a hold of this copy, I highly recommend it, because it really takes you through why immigration and nationality are not distinct in the UK. Why are they always being legislated in the same instrument? Why is it always connected to what happened in 1948? Why do we go back to it? And I think Anne really, in her work, brings out these different changes in historical time and how categorically people have been included and sometimes excluded through various instruments into British society. And I hesitate to use the word citizenship because for very long it wasn't about citizenship, it was just subjecthood. So we are seeing what subjecthood was, then how it becomes an idea of citizenship, how people are categorically included and then excluded sometimes, and all of that through the statutory changes over time. And this book lays that out. So again, I would say I highly recommend this book for you if you want to learn more about this area. In my work, I use this book also because it stops with the very interesting cliffhanger that the UK has now joined the EU. Sadly, we've gone a few more stages since then. And for me, it's quite useful to understand what's going on in the time of Brexit. And what happened during the Brexit referendum is you see references to nostalgia for empire. So there are many people who have written about this, but most notably maybe the Nobel laureate Abdul Razak Gurna. He said that the British Empire is still important in Britain, and you see that manifested in how the Brexit referendum took place, because there was empire nostalgia. We see this in Hirsch's work as well. In her book British, she writes this, that the ghosts of the British Empire are everywhere. and nowhere more so than in the dream of Brexit. So is Brexit about this regaining of control and feeling like one is part of the empire? But for me, that question aside, what is interesting is that during the referendum, there was a lot of talk about how EU nationals displaced Commonwealth nationals in the order of inclusion in British society, and a lot of relationships with the Commonwealth were substituted with relationships with the EU instead. And there was a sort of setting up of EU nationals against Commonwealth nationals, even though there is no definitive proof that Commonwealth nationals in the UK are even a common bloc. In fact, definitely not. There are very diverse, divergent kind of stances even on the referendum. But this kind of pitching of one set of migrants who were included in the past and then sort of declined with another set who sort of got included at the same time as Commonwealth nationals were declining in inclusion, and then pitting them against each other. It was a very common part of the reporting on the referendum and even the post-Brexit trade negotiations, you see the same kind of talk. And I think if we use the framework of alienage and the ideas of the stranger and looking at the breakdown of empire, what you actually see is that at various points of time, the law has operated to include and categorically exclude various groups. And each time there is an inclusion or exclusion, it affects many more than the target group. So I will demonstrate to you these points of convergence and how it affects more than, so anything that happens to EU nationals, for instance, has had ripple effects on Commonwealth nationals and other third country nationals, and it's much wider than any target group of exclusion. So that's one of my arguments. So let me quickly, I don't want to spend too much time on the idea of what the historical developments, but I want to tell you about a little bit about what happened and why the entire history is fraught and linked to colonization. It is because in the times of the British Empire, there wasn't any one fixed category of who is a British citizen. It was all defined through subjecthood. And a British subject, it didn't matter in the eyes of the law where they were born. They were supposed to have the same sort of relationship to the sovereign. And this was kind of important for establishing territorial claims and expanding through colonization. But at the same time, when British subjects were traveling within the empire, it wasn't that they were freely traveling. There was an idea of free movement because often you needed the subjects to be, say, sort of part of the British Army or serving in British outposts in other parts of the empire. But there were very often actual barriers to movement as well. So between the wealthier parts of the empire, who were mostly the dominions, which became autonomous faster, it wasn't really possible for mostly non-white people from the colonies to travel that freely to these places. And especially as they gained control over their own borders, they started restricting people coming in from the colonies. And this was well known. It was known at the heart of the British Empire too. And I have a famous quote in my paper from Lord Chamberlain, who said in Parliament that, you know, it's perfectly understandable that people in the dominions, they will not want these Asiatics to come in and stay with them. And we understand that and we support that they don't have to do that, right? So it was very well known that there was nearly no real free movement. On the other hand, there was a pretension of there is an equal subjecthood. And what happened subsequently after decolonization was that dominions like Canada started legislating their own citizenship acts. And they made British subjecthood and the holding of British subjecthood dependent on first being a Canadian citizen. So which was a way of kind of extending citizenship to French Canadians who were not British subjects. But this threatened Britain's global position. And I think Hanson's work on this is phenomenal. He really shows how the 48 Act then was a response by the British government to say that actually British subjecthood is still the most important thing. So if you are a British subject, you can enter and reside here in the UK. And it's it's phenomenal. This act just has this open doors effect. But we have to put it in the context of the time. There wasn't that type of mass travel at that time. They were probably not expecting the people to actually travel. But most importantly, they were not talking about race and ethnicity and imagining people coming in that numbers from the erstwhile colonies. And they didn't anticipate the backlash as soon as people started traveling. So what happened very soon after 1948, when the doors were open to people from the erstwhile colonies, was that there was racist backlash. Immediately, it's an era of tremendous amount of racial hatred and tension. We have the famous speech by Enoch Powell about the rivers of blood. We have, all sorts of this is mayhem now. People who were coming to help rebuild Britain after the war are actually the same people who are crowding out everybody from hospitals and schools, arguments which we can recognize to this day. So this then leads in the 60s to immediately a series of acts which start tightening the conditions of entry and residence. And one of the first effects of this was felt by the East African nations. Now, East African nations in the 60s, they were fleeing from the despotic regimes, which were discriminatory towards, again, different ethnicities. So Asians were not welcome anymore in East Africa. A lot of them had British passports, and a lot of them had British passports which were issued by the colonial governments. So what happened was the 1962 Act introduced a sort of bar on using passports that are issued by colonial governments. So now none of these people then can enter on their British passport. So they are just blocked from this. And series of acts like this start and putting in conditions of ancestry or blood links. So you have to have an ancestor who was born in the UK, a grandparent or a parent who was born in the UK territorially. Otherwise, now you can't claim this. So which means, obviously, if you are a person from a former colony, like you are from the Caribbean islands, or you're from India, you're much less likely to have a parent or a grandparent who is born in the territorial limits of the UK as compared to somebody in Australia or Canada, a white person who is likely to have an ancestor. So we see the racialized effects of these laws immediately in place. And again, it's when the law, which was all embracing in 1948, starts creating foreigners, starts creating aliens through blood links. And I call this in my work a reverse decolonization, almost matching the decolonization territorially in the population, mirroring it, but doing it in the sense of expelling or not allowing any other ethnic minority person from outside to come in that free manner. So it kind of undoes that whole 1948 Act scenario. So this is kind of a short summary for you on what happened between 70s. Ultimately, in 1983, we see there is nothing remaining in terms of any special rights or protection for Commonwealth citizens. So it's after the series of organizing attempts by law, in 83, eventually, now they have absolutely no separate entry or residence rights. I say that carefully because I do know there's still a voting and controversial Representation of People Act kind of rights still there for Commonwealth nationals. But in terms of entry and residence, it's not there. And not only that, from 83, we don't have birth citizenship in the same manner as before. So it's now only birth plus blood links. It's no longer just by territorial birth. The effect of all this is when we start having the hostile environment legislations coming in, which require document checking, a lot of the people who did enter in the past under the previous statutory regimes do not have any requirement to have any registration at that point. So it was only through the declaratory effect of those statutes that they entered. And when the hostile environment legislation starts saying that landlords or doctors or employers can ask to check your legal documents to ascertain your status, they have nothing to prove that they are actually British because they didn't require it. And this results in the deportations, the Windrush deportations and the scandal. And I say this because it's a point of convergence. A lot of this has been happening to EU nationals who were rough sleeping, or the deportations of EU nationals have skyrocketed during the time just before the referendum and post-referendum. And you can see mostly it's people who are rough sleeping or in between jobs. You see their deportations again linked to document checking going up. So I consider it not about EU nationals versus Commonwealth or earlier inclusions, but part of the same sort of exclusionary story. So really what we see for EU nationals as well as for Commonwealth exclusions is a system of categorical creation of foreignness, a creation of who is an alien. People who might have even been there for a long time suddenly are not one of us. They're aliens. And that is happening through the operation of laws, even if it's slightly differently for EU nationals. For EU nationals, it happens more in the settlement scheme and having to register for that. If they fail to do it, as many vulnerable EU nationals could easily and have done, then, or if you have pre-settled status and then you have traveled, you suddenly find you have become not one of us, alien. So that's the creation of foreignness operating there through the operation of law. So the points of convergence, I think, are very clear, especially if one looks at 3 different examples. And these are some of the age-old motivations for migration control as well. The first is, I think, the protection of the welfare pot. It's presented as one of those things that you need to protect the welfare state and its facilities. You need to protect the welfare pot. And this is important because it affects not just EU nationals, it affects everybody. And I'll give you an example of how this operationalized and changed things. So there was a time when EU nationals could bring in their family members who are third country nationals through a completely outside the immigration rules process. They didn't have to show that they have a minimum income for their partner or their foreign family. So these are third country nationals who could come in with their EU partners and family members. But British nationals, when they wanted to bring in their foreign partners, had to show that they had a minimum income to support them. And you can see that this creates a hierarchy in which third country national partners of EU nationals were able to access, to enter and reside, whereas those of British nationals were not able to do so. Now, after Brexit now, everybody has become subject to the minimum income requirements. Who has this affected? It hasn't just affected EU nationals. It has affected those family members who were from erstwhile Commonwealth or any other third country. So it's a much wider effect. And it's all in the sense that if you do not meet these minimum income requirements, you're more likely to become a welfare dependent. So it's about protecting the welfare pot. And the Supreme Court has accepted this as a really good reason to have these type of policies in place in the case. So that is a point of convergence, I think, in which you can see how the exclusionary logic affects way beyond just a target group. The second one, I would say, is about where the access to citizenship itself has changed. The removal of jus soli. Now, for this, instead of the British example, I'll have to go to Ireland because there is a better EU law linked example there about how third country nationals have got affected. It was the famous case of the Chen case, in which a Chinese woman settled in Northern Ireland and had a baby there. So this is a third country national having a baby. The baby acquires Irish nationality through birth, through the operation of the law of the soil, jus soli. Okay, then Ms. Chen wants to travel with the baby to the UK, exercising free movement rights, and the UK government refuses that. And this case reaches the European Court, and eventually this is established that it is truly a free movement right to move because the child is Irish and has the right to do this. This fed into the citizenship referendum that was happening, ongoing at that time in Ireland, and eventually there was removal of jus soli in Ireland. I can't say it's causally linked. It's not like Chen case happened and immediately. They were sort of contemporaneous, and the debate was already ongoing. But it shows how the removal of jus soli and is linked directly to sort of the access to wider EU free movement rights. In the UK anyway, in 1981, the 1981 Act took away the jus soli access. By 83, it was all gone. So we didn't face the same thing, but the link about access to citizenship and how it has narrowed down with the presence of third country nationals, I think is quite clear here. And the third one is most famously now about cancellation and national security. Again, so we can see it's about who has membership, it's about protecting resources, and the third major reason for migration control, which is national security, so conduct and behavior of people who might, in some way pose a threat. So for cancellation, what we are seeing increasingly is it's not just, even if a particular ethnic group or religious group has been primarily subject to this, it can, in theory, legally apply to many, many people. Anyone who has another nationality or another national connection, they will not be rendered stateless and can be deprived of their citizenship if if there is a reason to do that. And there's wide discretion with the ministers for this. And what we see is that if you're a naturalized citizen, you can even be rendered stateless through this. So essentially, what this does is it makes one group of people even more vulnerable, but it does make everyone who has any connection with another country vulnerable as well. So again, it's not like it's just one set of people or one category. It's much wider than that in terms of effects. So the target might have been a particular situation or group, but an operation is much wider. So if it's really focused and targeted only on one group, we can say it's discriminatory. But if it is potentially including a lot of people, there is also the issue that it affects anyone who has some sort of a migrant connection, because they are the ones who will have an alternate link to another country and will come within this. So again, I think this is another point of convergence, which shows how the idea of foreignness is quite becoming wider and wider through the operation of law for various reasons. So when you strip people of citizenship, especially, what right are you taking away? It could be that we're talking about the right to have rights, as Aaron said, but actually, if you look at it in the British context, if you look at it in the context of immigration and nationality, Franz Mann's treatise actually points out it's really about the right to enter and the right of abode, that's right to reside in a country. So if a person's citizenship is stripped, that goes immediately, they're outside the borders, they're foreign. So it's a really strong bordering function through this. So I'll talk about this more in Q&A if someone wants to know. But I tried to capture how the various dimensions of regulation of migration control actually work within the framework of rights, where they intersect. And you can see ministerial discretion taking away from a big chunk of rights, Parliamentary sovereignty always sometimes always comes in when the statute is such that it's very difficult to challenge and it's taking away some rights. Public health, national security, all of these things are coming in this framework. And these are non-exceptional. It's not happening in times of so-called war or even an exceptional threat to national security. This is normalized and everyday, which is interesting. Right, so I'm going to bring you back now because I'm almost at the end of my allotted time. So I'm going to bring you back to the concept of alienage and what is its role. It's not enough to just think about citizenship. There are many more statuses in between, especially in the context where we have derived things from subjecthood and where we have had eras of different people being included and then excluded in the manner that has happened to people from former colonies or from EU countries. Then we have to think about the tensions between entry and long-term rights of stay. Sometimes you can have a regime that allows entry very easily, but the substantive rights holding is weak. Sometimes the rights can be protected well, but the entrance then becomes really difficult. So is there a trade-off between these? There are tensions between having equal status and having substantive rights, as we have seen in Bosniak's work and Meigai's work, I think. That is through the idea of the citizen alien and the distinction of having people who are in between, not really aliens or citizens, but somewhere in between. And that's where I think idea of Zemmel's stranger as a disruptive category, as someone who might go tomorrow. How do we deal with that person in law? Is it enough to go with the age-old, century-old way of thinking of people as settled populations, or we need to think about the fact that people do move and move multiple times in their lives? Finally, to come back to Mary Kondo's work and to tell you that what's missing in immigration and control and the nationality legislation is definitely not all at once. It's not organizing all at once. It's treating people as objects. So that method wouldn't work anyway. And also, when in the KonMari method, there's a lot of a focus on authenticity. How is this object serving you? Is it an authentic need? What happens? And I think the whole underlying objective of immigration control has lost an overriding value. It has become suspect in many ways. So we don't have that authentic link anyway to organizing through these statutes. So it's really time to think about what's the purpose of these kind of legislation? What are they actually trying to achieve in time? Is it enough for law to simply keep creating and recreating concepts of foreignness? I will stop there. By the end of the time, I can't wait to talk to everyone. Thank you.
Well, thank you, Devani. That was a fabulous paper. Maybe we can stop screen share now. And I'd like to also invite our audience members to raise any questions they have in our Q&A function at any time, and I will moderate those questions. But I'm going to use the chair's privilege to begin the discussion. And I've got lots of notes that I've been writing down. And I think I'd like to start with Mary Kondo, but a slightly different take on how Mary Kondo might be relevant. When I think of Mary Kondo, and I can't say I'm an expert on the philosophy, but I would think of things as being out of place. And in a way, and I love how you began with the stranger, which is a nice idea of, but also I wonder if there's a social anxiety that's created by the idea of someone who is in a sense out of place, who doesn't know their place in either sense of the phrase, and therefore can't be easily understood as in terms of where they belong. And much like things that don't fit neatly into someone's notion of what should be in the drawer or in the closet. Does that make sense, Devani?
Absolutely. I think that's a really, a really good analogy for how the displaced person and the sort of out of place object are comparable, and leads to this need to understand and organize and see where they will fit in better. And the law seems to be trying to do that tidying up, accepting that people and their lives are much more complicated than those objects. So you can't actually put them into those kind of compartments, and people have links with each other. So whereas you could do that with objects, you can't really do that with people, because they will have relations with others. So lo and behold, EU nationals have third country partners, and all these kind of connections will come out, which doesn't make it possible to do it quite in the same manner. But yes, that is sort of the reasoning that took me to thinking about what is the law trying to do here with these categories? How is it trying to tidy up as well? So I'd like to.
And indeed, on the Marie Kondo theme, Kat Langley asks and notes that, of course, Marie Kondo thanks the items she discards. And that in the era of the hostile environment, can you imagine that kind of symbiotic relationship in British migration?
Absolutely. Thanks, Kat. I think that's one of the core things, that you have to be grateful even for the items that you are discarding in the KonMari method, because they have been useful for you in the past. And so you want to give them thanks for it. And she has all these kind of rituals for thanking it and putting it away, which is definitely not, let's say, the Home Office approach when thinking about recategorizing people, or thinking about what joy they bring to you in your life. No, definitely not.
And another question from our audience, who this listener asks your take on the term crimmigration. Do you find it a useful term in thinking about foreignness in law? For example, who will be deported after release from prison?
Yes, I think it's useful because it captures the use of criminal sanctions and the increasing use of criminal sanctions in migration control, and how immigration control now has become more and more penal in nature, and has actually started replacing even criminal justice activities. So part of the rationale for canceling people's citizenship is you don't need to put them on trial anymore. They're outside your borders. They are in Syria, wherever, in some conflict area. So you don't even need to use, at one level, you don't even need to use your criminal justice system. So it's replaced it. And on the other hand, you could use increasing amount of criminal law to make migration control run and operate more. So for example, by criminalizing solidarity with migrants, or the protests at sites, like people who tried to stop the plane being deporting people, those type of uses of criminal law. So I think it captures that dynamic interaction between criminal law and migration control in a quite a helpful way.
And in many ways, a natural follow-up question from Bethan Lant, who asks if the erosion of non-citizenship rights might be a precursor to further erosion of citizenship rights more generally.
So if I understand this correctly, if it's more about people who have not yet become citizens, or maybe, so there's a whole idea of why I'm hesitating is because there's a technical understanding of non-citizenship to refer to people who don't have legal status, but who almost exist in a parallel economy. So maybe undocumented migrants who have no kind of legal status, but are almost essential to the economy by their work through the parallel economy. So does their presence also, and the fact that they're kept there, does that mean there is a decline in citizenship rights overall? I think one can answer this in various ways. In some ways, it reminds me of Derek Bell's, faces at the bottom of the well. This is what everyone else is almost measuring up. I have rights, whereas these people don't have it.
Mm.
But so that's calibrating against that. But on the other hand, if you start denying people rights, how genuine can the rights that you keep for some be? At some level, it's not going to be universal. And what you have made more and more exclusive is bound to show signs of wear and tear, I think, over time. So is it possible to have only a privileged group which have rights and deny that to others? That's
I think
wow.
I wonder if the point of is that we seem to be living in a period where rights we might have historically thought of as privileged rights are themselves being eroded, even for those who are quite privileged. So, right to protest, etc. That I think maybe the listener was pointing to that there's a broader threat to rights going on at the same time.
Yes, I mean, there are arguments that we are reaching the post-human rights era. As it sounds terrible, I know, but it's almost like, is this the end of, we've reached the post-refugee convention era with our Nationality and Borders Act. We are reaching, we're not really, statelessness has become back into the play. So in some ways, there's an end of consensus that was there in the end of the Second World War. So definitely there's an overall decline of the universality of human rights itself. So I would say, yes, we do need to situate this within that broader. So it's a great, thanks for that. It helps me to link that up as well.
I found really interesting the discussion about, say, the privileged green card holder, the sort of citizen plus type, which I think there are lots of interesting parallels here. And I know that there have been interesting discussions about how some global citizens are either privileged or deeply threatening, depending on their socioeconomic, racial categorization, etc. But there's also an interesting way in which the globalized, even the privileged globalized citizen who is very privileged, is seen as somehow not belonging as well. And I think of some of the comments that are made in some quarters around the prime minister having, that about his connections to the U.S. and his green card there, as somehow undermining his authenticity.
Yes, absolutely. So this has been a bit of a journey for, I think, multiple nationality holding. So in the beginning of the 20th century, there was absolutely a distrust of having a different nationality. And it's in the context of war and who is the enemy and all that. But the Hague Convention soothed that out. And post-war, it became like an understood thing that you could have your center of being in one place, even if you have connections with other countries. So we have people like Peter Spiro's work then saying that dual nationality is now common and accepted. And, in fact, it's quite appreciated that people are global and they have all these networks and connections. But again, I think we're seeing a journey out of that. And we have emerging suspicion of multiple nationality holding. And I think you're absolutely right, just as the other question about human rights. They're all sort of linked, I think. And I dread to make these really broad claims. I'm a sociologist lawyer, so I don't want to make huge claims. But I think we can see the connections with the reemergence of strong nationalist movements and a reemergence of nationalism. So whenever these type of stresses and trends of nation states and their self-image come about, you see sort of fluxes in multiple nationality and citizenship. That's sort of my understanding of this in a broad framework.
But I think that's right, and it becomes ever decreasing, ever narrower category of the authentic citizen who belongs, right? So it becomes, it never broadens. It only gets narrower and narrower. So eventually, if you disagree in any way or dissent, you don't. You're somehow there's a lack of belonging, I suppose, authenticity. But an interesting example that I think, just for obvious historical reasons, a category that doesn't fit, that is, I think, quite disruptive, is the impact of Irish citizenship in the UK, which is its own kind of odd, and oddly given, or ironically, given the history, the obvious history of discrimination and prejudice in this country, but it has somehow emerged as at least in legal terms, a kind of privileged category.
Yes, I mean, I've been joking about the fact that I have a Kerry Blue Terrier, an Irish dog. Can I, through him, find a connection with Ireland, please? But yeah, jokes apart. I mean, and there's a long history between the two islands of sometimes almost embracing each other in terms of residence and entry and free flow of people, but at other times absolutely banning everyone from Ireland from entry into this island. So it's gone from one extreme to the other. But of course, the special status now is because of the Common Travel Area Agreement between Ireland and the UK. So it's based on that it remains a separate and a disruptive category, as you would say. For this, I think it's a really good example of that.
Which is combined with EU citizenship. So it becomes the kind of ultra powerful form of nationality.
True, but also puts one in the potentially suspect if they're looking for the multiple nationality in the citizenship stripping. So one where it becomes a problem because it could be the other nationality.
I mean, it was great to hear again some of the history, the post-war history, and I must say I had never kind of joined the dots to think about the 1948 law as in part being a result of white dominion type legislation. So that I thought was really interesting. It also made me think of, and you mentioned the parallels to today, labor shortages, that there's this tension between trying to control migration and the need for migration because of shortages in the labor market. And I think that's just, and you can see, I think now in a lot of the discourse, that's just unresolvable in the way in which it's articulated. Unless you're going to have guest workers who don't acquire any rights, it's very, there's no way around it.
Yes, I mean, for me, what is interesting is that if we look at some of the debates that were happening historically, I mean, even in Canada, in terms of who will work in the mills and which kind of workers, they require people, they need labor. And even the UK was actively, in the post-war period, advertising. There are recruitment posters that come and rebuild the mother country. This went out to the former colonies that help us rebuild. And at the same time, the tension between then who does apply, and if they're coming alone or are they going to bring their family? So is it going to be about just one person? And if it's a male laborer who's joining, will will the conduct be all right, or will they turn into a national security risk later? And it's the same kind of framing of labor shortage, but the links between that and race, ethnicity, and potential kind of being a threat assessment.
And different ways in which that's a threat. Threat to the threat of I think it's true in a lot of colonial contexts I've read about, the threat of the single male migrant to in different ways.
Yeah. And sometimes it's kind of funny because it self-perpetuates as well. So because the 62 Act it said that prospectively you need to have your passport issued not by a colonial authority, and then subsequently the 68 Act started putting in the ancestry links, people started realizing that the immigration controls were tightening. And so it became about quickly bringing over the family to join you before that closes. So in some ways, it increased migration in that period, contrary to what they were trying to achieve as well.
I mean, the harkening back to empire, which I think has been an interesting and somewhat bizarre discourse throughout the Brexit period, of course, leads to almost inevitably what's happening with the negotiation over, rather unsuccessfully, of trade agreements because of the unwillingness to talk about migration in those agreements. I wonder if you had any comments, reflections on some of the trade issues that have been arisen, and almost the surprise that this is what negotiating parties would want to talk about.
Yes, I think, again, the promises and political rhetoric at the time of the referendum, and speaking to Commonwealth countries and nationals as you will be this trading bloc and it will be easier to take control of borders, so it will be easier to recruit the best brains from the Commonwealth. And there was a lot of like, whoever is the most in global Britain, I think I'm trying to quote the exact language, global Britain, whoever is the most worthy person to come in and work will be welcome, and we'll be able to do that after Brexit. But of course, once the process is over, the question of having any kind of preferential entry associated with trade deals was very quickly dispelled and is not going to happen. So we see that quite rapidly happening. I think it happened with India trying to talk about preferential Indian workers coming in. I think we've taken it to quite another extreme now because of the language about reducing international students numbers. So it's not just about the trade deals, even the existing systems which have been quite beneficial for the country in terms of international students coming in, the rhetoric has changed about welcoming them.
Well, and it also, another example, I think, of that in the context of the Commonwealth, and this harkening back to maybe partly by the Crown as well, to this sort of glory days of the Commonwealth, is the prevalence of visa requirements for many of the certainly those Commonwealth countries that are not the old dominions, where there are visa requirements on them. So there's a differential treatment there as between and within, and not surprising, the Commonwealth.
Absolutely. So visas, and also there are special visas like the ancestry visa scheme. If people want to, for example, come from Australia or New Zealand, I think it applies to quite a few of the former dominions. They can come in on that, but that was never extended to the older Commonwealth countries.
I'm once again welcome any questions from our audience at any time. It's a fascinating study. I mean, where is this? Can you talk a little bit about where this work is going and what outputs you're planning? What's next?
Yeah.
You've been incredibly you published so much. What's next on your plan?
So there's a book on the plan. So the book has got, this is not the main focus of the book, but the book has got a more scale-based approach to migration control. So it looks at kind of migration control at the continent, country, city, and going down in scales to microsites of bordering and different kind of scales, so bringing in the scalar context. But this is more a chapter or an article at the moment, it's a bit of an amalgam from a couple of different articles that I've been thinking of right now at this stage.
Well, great. Well, I think we're going to draw it to a close at that point. It's a fantastic study, great paper. I certainly learned a lot. I'm sure our audience members did as well. So I'd like to once again thank you, Devani, for joining us today, for presenting such an incredibly rich and deeply textured paper. I would also like to thank our audience for joining us and for your participation. Until our next seminar, whether remote or face-to-face, as we're now offering some face-to-face events at the Institute, I want to thank you again for joining us, and goodbye for now, remotely from the Institute of Advanced Legal Studies in London.
Thank you so much. Thank you, Carl. Thanks, everyone. Bye-bye.